I'm here with Professor Sudhanshu and Professor Praveen from NALSAR University of Law. And today we're having a discussion about the business of law, how to train young lawyers to be entrepreneurs, to be involved in business, to set up businesses on their own maybe, law firms, and maybe provide general counsel for other types of businesses. So I just want to start by asking the question, as you're training lawyers at NALSAR, how are you approaching this concept of business as law?
Right. When we design our course, and particularly courses in the senior batches, 3rd, 4th, and 5th years, we take an effort to design the course in a manner that the mode of instruction is not entirely bookish, right? And it has to go beyond the books, because the practice of law, as I said, is different from the books or the law that is written in the books. And thereby we try and inculcate in our course structure a lot of involvement, a lot of input from the industry, from the lawyers, and we do try and make an effort to teach the subject as practitioners would, or practitioners would take it. So for example, in a course of company law, say for example, if you're teaching how to incorporate a company, in addition to doing the course on company, in addition to doing the sections of how to incorporate a company, we also parallelly do a workshop on how to incorporate a company, so that students have a first-hand knowledge to navigate through, say for example, the Ministry of Corporate Affairs website, to see firsthand what the memorandum or the articles look like, to understand what is the fee structure, so that tomorrow when they form a company of their own, or they're forming a client for their clients, they have that understanding and they do not hesitate in terms of the knowledge, in terms of incorporating company. Just taking an example. So along the course, say for example, in business laws or other courses, we try and do parallelly all those stuff so that they're trained for better facing their clients, or tomorrow if they want to enter into business themselves.
Right. Well, so I come from a management perspective. So as somebody who's working with entrepreneurs and working as in the mentor group with very young entrepreneurs. So I come from a business side, and purely from a subject perspective as well. So we come from a management school as well. So NALSAR also has a management school. So I have a slightly different take on the entrepreneurship and law perspective. So there's this fairly famous view that law is a deterrent to business, which is kind of how people perceive law. So stay as far away as you can. So if you can, hopefully. But what we try and bring in our perspective is to see if you can see law as an aid to your business. Where does law really add value to your business? And if it does, how would you actually figure out? Is there a sequence in which you should try and look at law or legal support so that the business can actually magnify the output? Let's say a 10x business, is law really a factor in a 10x business? Or is it pure commercial blitzscaling that matters? Right? So I come from that perspective, partly because less of a lawyer and more of a business school professor. So that's where we have the entrepreneurial training programs, where one of the critical aspect of learning, or rather one of the critical aspect of the experience of entrepreneurship, is to see if they can look at business as a perpetuity. How do you look at business as a continuing activity, not necessarily a one-time thing where you make money and then somehow get out of it, right? So how do you stay in business for long? And law has a very important role to play. So that's something we would want to actively work on.
That is one of the advantages that we have at NALSAR. We have a business school and a law school working together. So whenever we design workshops, when we design course curriculum, it's time and again we have interacted among faculty, the exchange of ideas among faculty, the exchange of ideas among students. So the business students sit along with the law students in terms of understanding of the structure. So say for example, I'm taking the same example, I'm starting a business. Both the acumen of businessman and a lawyer is required at the time of incorporation. So we do that together in terms of skilling the students in terms of doing that.
So Woxsen here has an incubation center where they have people from different backgrounds that are coming together in one space and working toward common entrepreneur goals, right? And they'll use the skills from these different people to start to build a business even from the ground up before they even graduate from school. So if you were to come in and speak to those students about engaging with law, what would you advise them in that case?
I'll probably take that because we really have a lot of focus on that. Somebody who is working towards business, it's mainstream for them to work on a business idea. But in terms of executing the idea, there are a couple of challenges that we start off with. At a very basic level, very rarely do you actually find a single founder being successful. You basically have to sit and discuss ideas in a safe environment where you're not worried that these ideas would be stolen. These ideas will actually be used by somebody else. So if you're working in a very constrained environment, you're not actually making teams. So you don't have anybody who is walking your dream, your vision, right? So on a business side, you're talking about articulating your idea, your vision better. That's how an incubator would train, a business school would actually train. But from a legal perspective, you would want them to understand the nuances of a partnership from a contract. Let's say, put together a co-founders agreement and see where do we end up, right? And this co-founders agreement is something that's going to last as long as the business itself, right? So if we really do not understand how we're going to engage with one person, if we are not able to sell an idea to one person, then probably it's highly likely you're not going to sell it to a lot of people outside. So integrating or weaving in law, one is, if you have a co-founder, how would you want to structure your relation with them? And if you were to see 5-10 years down the lane, how will this relation actually pan out? There are so many situations that will come up. Business doing well is a good one. Not doing well is probably more likely to happen. And me getting married is one. Somebody else, new job, giving a 3x offer. So many things that are possible. How would you protect the IP? Or how would you protect the know-how that you've jointly built? How would you actually ensure that there is a clean exit for you as well as the people you're working with? So if you're able to articulate or explain this better, if you're able to layer the negotiation better, then probably you're building a solid foundation for a good business. This is one example, but you can just take it to every contractual agreement that you do, SSHA, SPA, whether it is investors that you're dealing with, right? At every point, a very good grounding into the legal framework will definitely improve the chance of a scale. Basically, success.
And to add to it, our university has long-standing relationship with some of the startup organizations in the state, and we have more than once come across startups and businesses saying that we do not understand the small nuances of law, for which we have to run back to the lawyers or the law firms, which again charge heavily. If we get a training, if we had a training in these nuances, in understanding these contractual terms, in understanding the implications of these agreements, these clauses, then it would have really helped us in terms of structuring the business. Again, structuring the business in itself from the legal standpoint is again a big headache for the startup businesses. And to structure investment agreement, to plan an investment from the legal standpoint, all these understandings if they have, in the courses that they do, say for example, it would take them a long way in terms of kick-starting their business much quicker, and they don't have to rely on legal experts to do that.
I think because you have an incubator here, I think you should pose this question to them. So really, if you're successful, so that's the whole idea, right? So you enter in, you would have raised funds, and your first round is usually from friends, family. What would you offer to them? How much equity would you want to offer, right? So there are two ways to approach this question. And one is purely from a valuations perspective. You do the math, numbers, look at the business. Try explaining that to your uncle or a friend. Try explaining all those values. And you're basically talking across a tea, coffee table. And so where exactly is this? So where are these $1 million valuations? So you'll not be able to justify a number. So if you end up paying a 10 or a 15% equity as a dilution, imagine the deterrent that it is going to be for further fundraising. So what would you do? If not a 10 or a 15%, you can't obviously educate them to take a less equity, a fair value doesn't work with them. So how would you actually deal with this situation, right? One obvious way is remove the valuation out of the equation. So intuitively, we try and work towards valuation because that's how our startup ecosystem, particularly in India, it's slightly unique because while we talk about product market fit, we mostly talk about it from a blitzscaling and valuation perspective, not necessarily customer point of view. So if you basically take the valuation out of the equation and offer them an equity enough with some sort of a conversion where on a good day, this is the valuation, on a bad day, this is the valuation, this is where you will convert, right? So if I'm not successful, I'm going to give you money back, hopefully. Right? So I'm not saying this is a very successful way of doing it, but this is definitely better than what you would otherwise do, a 10 or a 15% off equity dilution upfront. And that I have seen enough cases because purely out of our consulting engagements, I've seen enough places where it's a deterrent for a VC to come in. They wouldn't want to enter into a company where a 15-20% non-engaging partner is present. So he has no role in the business, no active value creation. So why would I create value for that 15% guy? And what are you giving to me? So I think questions like this will intuitively push us towards looking at the central lore of law, if not its presence. And in an incubation setup, I think this has to be mainstream. So we have to look at the business life cycle, then business as a blitzscaling activity.
One of the things that I've experienced in the practice of law, and I've advised a lot of businesses, is you have startups that have a certain amount of capital, right? And what they do is they try to, from the outset, do some sort of risk assessment. And sometimes they meet with a lawyer to help them do that, but sometimes not. Sometimes they do it on their own. And ultimately, they assess various styles of risk, various types of risk, but the ultimate risk they're assessing is whether they're going to fail. And in my experience, these businesses that fail don't fail because they have a bad idea. They don't fail because they're unable to market to customers. They fail often because they don't have enough cash flow, right? They just don't have enough money to keep the lights on, even though the idea is good. The thing that will eliminate them almost every time is a legal issue. So this legal issue comes up and they run to the lawyer and then they get charged a astronomical amount of money to sort it out. And so what I often advise businesses early on is bring a lawyer in on the ground level as a partner in your business. And while it seems like you're diluting your share value, right, or not your share value, but your amount of ownership of the business, while it feels like you're diluting that, what you're doing is buying insurance ahead of time so that when that legal issue comes up, you have somebody that can handle it. But more so than that, you've reduced your risk, right? What you're buying is a reduction of risk because they can tell you before you run into the legal issue, hey, you're headed into this area of danger, don't do that. Right. And that protects your cash flow. So protect your cash flow at all costs, and usually it gives you enough time to get your business up on its feet, get it running.
Now, interesting that you point out because there are a few startups, law practicing firms who are startup focused in the sense they move away from the traditional bill by the hour approach, right. So which is practically the bread and butter in the law firm business. And they do a milestone based activity where they're sitting on a strategic board instead of being a consultant. So much younger lawyers that I meet, so what they come in as, see, there are functional milestones in a business. So if you are an entity, then you have to do, there is a certain basic compliance that you have to follow. You don't worry about it, let me take care of it, one. Two, anything related to a contractual engagement that you have to enter into, don't do it with hope. So let's be clear, and I'm gonna take care of that. So the responsibility of the contracts are with me. In this, the payment models are actually interesting. Instead of doing an hour or a bill by hour model, they're coming up with a deferred payment or a milestone based model where assuming you go to a certain scale, then this is what I'm going to take away, irrespective of the scale. So whether it is a 10 million company or a 100 million company, I'm going to have a base fee plus equity in the business. Yeah. So at every conversion factor, so whenever there is a milestone hit, I'm adding equity, and then I'm adding a base fee. So eventually when you become a cash flow positive entity, then let's talk fee like a regular conventional business. Right. So what this is doing is predominantly taking away the risk of compliance oversight from the promoter's mind. So anyway he has enough things to worry about. But I think this is a very big pain point that can be addressed.
And also in terms of long-term structuring that we're discussing, long-term structuring of the company, while at the time of formation of the company or at the startup stage, structuring issue may not be that important, but it becomes a big headache as you grow, and thereby structuring in itself becomes an issue which can be tackled if you have a legal expert on board from the very beginning. So it reduces, as you're right, it reduces the risk to a large extent. Yep.
In fact, this is the governance structure for startups is not nearly the same as how you see it for a regular company, which is a board-driven entity. So a board is ultimately responsible. So there is a certain level of fiduciary role that they play and decisions, rationality of the decisions. But in startups, primarily the promoter-driven or star promoter-driven startups, you will find it very difficult to justify a reason or to justify the rationality of certain decisions. You can pick up companies, fairly big companies, Zellingos or Car Mechanic. These are all high-profile companies, Go Mechanic, right? High-profile companies, and you will kind of see that short-term decisions are actually ruining the companies. So these are all $500 million or $1 billion valued and more valued companies, and they're basically crashing down. So irrespective of the fact that it is private capital, there's not public money involved, but purely from an employment perspective itself, we can't ignore startups anymore. And as a startup, it's literally the responsibility to, to be rational. And if you're talking about rationality and governance, if you cannot afford a distributed board, try and bring in a lawyer who sees business the way it should be. A legal entrepreneurship, I think, is a direction which we are, I think, a little behind on how quickly it should have actually evolved, but it should evolve. It's a way forward.
One of the things you mentioned was that you're teaching students on how to structure businesses, and that everything doesn't have to be done in some traditional way. There's a variety of different ways to raise capital. There's a variety of different ways to bring people on board, to structure ownership shares. All of that is kind of taught in a business school, and I think business students are comfortable with that. Once they finish school, they have these ideas for how they want to structure their business, and they work with the resources they have to be able to structure within their limits. Law students, on the other hand, aren't taught that generally as part of their education. They're taught law, they're taught code sections, and they're taught compliance and these things. How do we shift education in law toward some sort of method for teaching law students how they can become involved in business at various levels?
Yeah, and the fact that a very simple thing has to be inculcated in their minds, that it may be possible that post their law school they also enter into business themselves.
Yeah.
And thereby it is important, either they're advising clients on business or they are doing business themselves. I have a lot of law students who have entered into business space, and they found it important that they do a course in business, certain business modules. What I want to say basically is just this, that if we were to inculcate that idea that you are going to be tomorrow's business or business people, and it is important to understand the nuances of business intertwined with law at the very young stage when you're doing law, it will go a long way in terms of you being successful in that business. And that is where the law schools have to design courses in a manner that we don't just teach them sections or rule books. We also teach them business and ideas of business, designing a business, structuring a business. And that is where the law schools have that flexibility. Apart from the mandated courses that the regulator says, we have a lot of flexibility into bringing the experts and electives and seminars, workshops, where we can join business and law and show them that it makes sense. It adds value to you, CV1, and it adds value to you as a lawyer or a businessman.
Right. So there's one interesting experiment that we're doing with few of our students. In fact, both me and Sudhanshu are in it. The idea is, assuming you do have a real client, so a startup which probably is in the middle of a transition, and a shareholder has to exit, a new shareholder has to come in with money, he's an investor. So this is the brief, this is what you get. To the fact finding. So there's no case, there's no structure, there's no case study that is being given to you. You're basically walking into a situation. This is a real situation. Can you get out of it in a structured manner? Can you advise or provide a structure? Surprisingly, the students did well. Their first response to the situation was overwhelmed and clueless. To be able to get the right facts out of all the noise, because promoter talks everything from business to his personal relations to the problems of the shareholders and everything. So there is no filter to what the information that he needs to give. So if you basically throw him in and ask them to filter out the right data, that itself was a very refreshing exercise for them. In fact, they've said that in as many words. To be able to structure a problem itself was a very defining activity. It's a defining moment. From there to actually look at or explore alternative solutions was one challenge, which is kind of they could figure out from the reading of the acts. But then the challenges of execution are coming in terms of suboptimal outcomes. So a lot of times promoters don't want the right decision, they want a reasonable situation, reasonable response. So path of least resistance, right? So how do you handle that as a lawyer? Lawyers are not trained to handle that. They need black and white. So to throw them into businesses or business situations upfront is going to give them that tolerance to be an entrepreneur. And I think this group will probably vouch for that, the student group that we're working with. What could be a 3-day activity in a classroom, they've probably been working on it for about 3 weeks, and still the solutions are there and thereabouts. So I think that tolerance will only come in if you have experienced the business firsthand, and more so the startup ecosystem firsthand. So for somebody, again, coming back to Woxsen's business incubator setup, so if there is an active encouragement of pulling in people, so law and business as co-founders, apart from the other streams, of course, there is a significant expansion or probably a bandwidth or tolerance that they will have, which probably will add to their startup or ecosystem support. They'll be able to do that.
I think one thing you said about this experience that you're giving these students as far as sorting through facts is something that I experienced in the legal field. When you study law, often it's compartmentalized. You study torts, or you study contracts, or you study criminal law, and then the exam questions are based on torts or contracts or criminal law. But when a client sits down at the table, they may bring all of those things. And plus issues with their family and issues with this and that, and they may give you an entire history, and you have to sort through that at the table while you're advising clients, very much like you described. And young lawyers have a difficult time with that because they don't have experience. One of the things that I really like about the way Woxsen is doing education is bringing in experienced people, people that have practiced law, people that have met with clients, and they're bringing students alongside them and saying, let's experience this together. Let me guide you as you experience it, so that when you get in that position yourself, it's not the first time you've seen it, right? You've watched an experienced practitioner handle it. You maybe have gotten the opportunity to do some of it yourself. So I think this idea of colleges moving toward more experiential learning, right? Not just classroom, not just exam-based, but experiencing the world as it is, I think is a wonderful thing. And I think India has a long way to go on that, right? I mean, we know even in law, the way that laws are written and the way that they are applied are quite different.
And that is why we are discussing why clinical education is so important.
Exactly right.
So apart from the courses that we do in the class, in fact, some of the law schools are trying to do that. We have still not reached to a stage where clinical education is the main thing in the law schools, but it has its own importance, and more we are starting to realize how important clinical educations are, because if you have to push students into litigation, if you have to push students into business, they have to have that experience before they go out in the market, and which they are not currently getting in the law schools.
Oh, in fact, a direction is we've just about evolved into a case study based model from a pure structured lecture model, most places in India for sure. So even this case study based model probably has a limitation on being structured itself, because you need an outcome for a lecture based model. If we find a way to integrate practical open-ended scenarios, and you have a practitioner view, as you were highlighting, a practitioner view, or somebody who has to really close a situation out there. And how does an academic look at the problem? It is going to add depth and breadth to the same thinking capacity of students. Yeah. I find that particularly valid. So purely out of my experience, I come from a practitioner viewpoint. I would rather close than look for structuring the problem perfectly, right? Whereas some of the professors they would wait it out and get the problem correct first, right? So this I think is more unique. The more practitioner involvement you have in your structured or in our structured academic programs, I think the more evolved will be a student mindset.
I mean, as you describe it, too, looking at things through a different perspective, right? Through someone else's eyes, or the way that they view it, is something that's really important to legal education, right? If you're preparing for litigation, one of the most important things you can do is turn the table and look at it from the opposing side, right? Because that prepares you then to present your litigation strategy in a way that's going to counteract the opposing side. So same thing in business. You're looking through these different aspects, getting different point of views, either through various academics, various practitioners, various students, but having more eyes on the problem, having more ways to look at it, comes to a better solution. Yeah.
So you not really know when the question shifts from a compliance to a tax advisory out of nowhere.
Because something we have been discussing as well, that a lot of education in the law schools is based on something which has happened already. That means post the matter has reached the court, right? So we teach case laws, we teach judgments, we teach laws, but everything has happened already. The dispute has happened. The matter has reached to a stage where the parties have to go to a court now, and there's a judgment already. And we teach those judgments as precedents. A lot of lawyers' work has to go before reaching the court, right? And something which is not discussed in the classrooms. Because 90% of the job of the lawyer is before the matter reaches the court. And if that comes along with the education that we are giving, apart from something that we are saying that, okay, this is the law, in terms of the process of litigation, is something which has to be added. If it gets added to the legal education, I think it would be really advantageous.
I think we should go one step back as well.
Yeah.
So to the extent that preemptive advising, or how do you actually not get into a situation? So, well, of course, the process of law is a good question, but the true value add a businessman would like is not to get into a situation.
True.
So where is the how do you actually strategically look at a business to probably 2 steps ahead of, would you please stop this, this is where you're going to end up. So I think that's practically non-existent, because all the promoters or the companies that we deal with, barring the top probably 0.5%, they have no semblance of any preemptive advisory on, particularly on the legal side. So there's no strategy for law.
They often get frustrated by it. These are dreamers, right? These are people that have these big ideas and everything is grand, and they're excited about the future, and they're 1,000 miles out, right, thinking about this thing, and then the lawyer comes in and says, well, you can't do that, and here's why. They often get frustrated. So there is a learning, combining these students together during their education, where they work through some of that and learn how to navigate different points of view, even if it's frustrating. I think is tremendously helpful. You had talked about clinical styles of education, how helpful that is, which I completely agree with. Doing that involves relationship, right? You have to have relationship with practitioners, relationship with various academics in certain spheres, because you have to draw from their experiences. How do you think in the future that schools like NALSAR and Woxsen might work together on things like this?
See, firstly, inter-university collaboration is something that has to happen. It has not happened in India, particularly in the law school, but it has to happen. We enter into collaboration with foreign universities which have nothing to do with our laws. But inter-university at the India level has to happen for our legal education to take a step ahead. Second, in terms of clinical education, I think in many of the law schools there are not many experts, but there are experts in each law schools which can be utilized by inter-university collaboration. So if I have at NALSAR a professor who is very good in clinical education and is doing very good projects, say for example, I think through collaborations, students at Woxsen can learn from that same professor. Similarly, if you have an expert on board at Woxsen, students at NALSAR can learn from that professor. So that collaboration, if it happens, then universities don't have to spend their time and energy looking for experts in the world. We have enough experts in and around, say, where we are located, for students to be trained.
Right. So this also brings up a view on this focus group, which are inter-university. So students which within the university, based on their areas of interest, we have a fairly vibrant club and cells as culture, but broadly, largely they're restricted to within the university or within a department mode. Probably the best case scenario is if you're able to do it beyond, so add a few universities. So what you're looking at is you don't need to pull people in, because that's one perennial challenge that a university has, to keep the clubs vibrant enough. But if you're able to get these focus groups going, a vibrant community of students with razor sharp focus. So I want to be an M&A lawyer, period. Now what? So you will not have a lot of students who want to be M&A lawyers in, let's say, NALSAR, maybe 3, 4 by name. Then if you have a set like that at Woxsen, at some of the law plays, NLUs, and this is a much larger focus area or a group in terms of impact. You would probably get in enough people with practical exposure, interest, or people who are working in these segments to be able to engage with them, rather than do it as a lecture series at a university. Right? To be able to pull them together and get on one practical case is probably doing justice to whatever they would have actually subscribed for. So that focus group is again something that we're working on. So I really would want that to happen at a inter-university level as well.
I want to close this out because I don't want to take too much more time, but give me just 1 minute final thoughts. Anything that's on your mind that we didn't discuss that you want to say?
Oh, well, so for somebody who's coming from a management perspective, counterintuitive, I would say that start with understanding the law. Because somehow scaling a business comes natural to an entrepreneur, but understanding the legal implications of the growth is definitely not. So if you're smart, try and understand how the law sees your business and your growth and what are the implications. So come from there, you're safe.
Very good.
Yeah, same interdisciplinary understanding is the need of the hour. And if you're trained in law, then you need to know business for your future success. And if you are in business, you need to know the nuances of law. That is the way ahead if you want to be successful in your careers.
Very good. Thank you, gentlemen, for taking your time today. Fantastic. I really appreciate it.
It was really fun.
Yeah. All right.